and the powers under section 156(3) under the Criminal Procedure Code is a topic which we quite often, day in and day out, even for a common public, while we read on the social media as well as on the print and otherwise, see that there are a lot of aspects being discussed under section 156(3). What are the facets? What are the dimensions? How there is a legal journey? And what are the powers given to the magistrate? And what are the powers with the common man who is aggrieved of the action and inaction of the police? Are there certain fronts wherein we will be having the insights from a renowned lawyer, Mr. MANISHANKHAR, and we are also thankful to Aparna, who was the connecting point to help us connect with him. And despite his busy schedule, but his passion to take things forward is what made us connect together. There's a demand for the sharing of the PPT. We have shared it on the WhatsApp group, but we are again sharing on the chat box. And I will request those who have missed our previous webinars, they can stay connected with the BeyondLawCLC YouTube channel. They can connect with that. And with that, I will request Mr. MANISHANKHAR to take things forward. Over to you, sir.
Thank you, Vikas. And one thing positive in this pandemic situation is it has brought all of us together from the nook and corner of our country. See, from the 2020 onwards, we have seen a rise in these webinars. The webinars itself, I think, a term coined for this pandemic. And it is so useful, not only for the seniors, but also to the young budding lawyers and also mostly law students. We have so many law students who take part in this or who are interested in these webinars. And therefore, we basically start from the first principles.
Yeah.
And these webinars are quite happening from now. We are in the second year. Here also, we have very regular webinars. In fact, we have one Madras Tax Bar, which deals with this taxation issues from 2020 onwards, and they are nearing now 150th webinar. Previously, they used to be very frequent, almost on a day-to-day basis, then weekly. Now, after the courts have started functioning and also normalcy is slowly returning, we are keeping it every month. Now, to go back to this today's topic, though elementary, as you suggested in your introductory speech, but it is a very important provision which is dealt with by the lawyers who practice on the criminal side from the trial courts. These petitions are being filed by those lawyers day in and day out, again to borrow your expression. This 156(3) is a provision where a person presents a petition to the magistrate, and the magistrate, if he deems fit, makes an endorsement and then directs the police to investigate. Now we are going to discuss what are the powers of the magistrate before issuing an order under section 156(3). Before discussing the provisions or the power under 156(3), which is the provision which sets the law in motion, we may have to also see the initial provisions under the Criminal Procedure Code, namely section 2D, which deals with the complaint. Complaint, you may be aware, is made orally or in writing before a magistrate. And if it is made orally, then the magistrate records it in writing, and then he endorses it for the police. Then police commences the investigation under section 2H for collection of evidence. Then it is done by the officer in charge of the police station, which is also defined under section 2O of the Cr.P.C. For criminal law to be set in motion and for the officer to register an FIR, which is the subject matter of today's discussion, section 154 will be the relevant provision to start with, because it deals with cognizable offense. If the offense discloses which is cognizable in nature, then the officer in charge of the police station has no other go than to register an FIR. Suppose if the offense or if the complaint does not disclose a cognizable offense, If it is only found to be non-cognizable, then the procedure is as contemplated under section 155. And as per clause 2 of section 155, the magistrate permission will have to be obtained to even conduct the investigation. Then 156 deals with the powers of the police to investigate a cognizable offense. Then the other thing is section 190, where a person appears before the magistrate and presents a complaint. And the magistrate, based on the averments made in the complaint, decides to take cognizance under section 191A or B or C, which I will briefly touch upon a little later. Then there is the final thing of taking the complaint on file is what we generally call a complaint, where under section 200 Cr.P.C, which captioned as the examination of the complainant. These are all private complaints. And once the magistrate sees that there is a prima facie case made out, he examines the complainant on oath, and also the other witnesses who are present at that time, he also examines them. And by conducting he can conduct an inquiry as contemplated under section 202. After conducting or recording the evidences of the statement of the complainant and the witnesses, if the magistrate comes to the conclusion that no criminal offense is made out, then as per section 203, he dismisses the complaint. Then that puts an end to the, or culminates or terminates the criminal proceedings. However, if the magistrate decides to proceed with the case, then he issues summons under section 204. Then it takes its own course. Then it goes for supply service of summons, then recording of evidences, cross-examination, etc. The origin of this 156.3 Cr.P.C, initially we could date back to 1882, chapter 14. However, this provision of 156 has not been provided. The first time, as per our this research, it was found in the 1889 code. However, there is nothing available to show what made the authorities or the lawmakers to introduce this section. However, in 1898, the Cr.P.C, part 5, chapter 15, this was 156.3 finds a place. Subsequently, it has also been carried over in the 1973 code. Chapter 12 of the Cr.P.C deals with police power, and sections 154 to 176 are dealt with therein. Chapter 14 of the Cr.P.C provides for the conditions requisite for initiation of proceedings under section 190 to section 199. Chapter 15, as I mentioned earlier, are complaints to the magistrate, which are dealt with under section 200 to 203 of the Cr.P.C. The setting of the criminal law in motion starts by presenting a complaint. Firstly, the informant, as he is generally referred to, or a person aggrieved, or a complainant, or even a third party can set the criminal law in motion. What is required to do? He will first file a complaint. It can be oral or in writing. If it is in oral, the officer in charge of the police station can either record it himself, or he can depute the writer of the police station to make a record of it. After recording it, he gives it to the informant to verify. After verification, he is required to sign it. After perusal of the complaint, if the officer in charge of the police station comes to the conclusion that it makes out a cognizable offense, then he has no other go to register a FIR. This is what is settled by the Honorable Supreme Court of India in the Lalita Kumari's case, which is also reported in 2014, volume 1 SEC, page number 1. This is a judgment by the Constitution Bench of the Honorable Supreme Court of India. Now the next question arises, do the police register all the complaints? All of us know the answer is a big no. Then what happens? There is something provided, it is also provided in the section itself, that if the police officer in charge of the police station refuses or shows or refuses to register the case, then the informant or the complainant has an option to send the complaint to the senior officer, who is usually the district superintendent of police as contemplated under section 36 of the Cr.P.C. Then what is he required to do? Superintendent of police again goes through the complaint, and he himself can record it, or he can depute the officer in charge of the police station. Being a district superintendent of police, he is deemed to be the officer in charge of the police station for all the police station in his district. Then the criminal law is set in motion. Now, there is also a third category of cases, which may be the subject matter of today's discussion, is that what if even the SP doesn't take care or show care, or he simply ignores it or puts it in the file? Then what is the remedy open to the person aggrieved? Then he has to, then this 156 clause 3 comes into picture. He presents a petition before the learned jurisdictional magistrate by appearing before him, and the jurisdictional magistrate is called upon to go through the averments made in the complaint, and if the complaint makes out an offense, then he can endorse it for investigation by the police. For that, the magistrate is required to apply his mind. There are any number of judgments which say that magistrate cannot act like a post office, and that he is not merely endorsing the complaint to the police to investigate. In fact, there is one reported judgment, which I will also refer to a little later, wherein the Honorable Supreme Court says, on perusal of the endorsement made by the magistrate, he simply endorses it as per application. That is the only endorsement made, based on which the police was required to commence the investigation. That order was challenged. However, the Supreme Court held that the magistrate is performing a judicial function. The magistrate is required to go through the provisions or the averments made in the complaint, and if the complaint makes out a cognizable offense, then he is bound to at least show application of mind and then endorse it to the police. Once the endorsement is made, the police has to register an FIR, then commence the investigation. Even for issuance of summons, Madras High Court has held in more than one case that a mere summons issued to the person concerned to appear, if it does not bear the crime number, which is the FIR number, then that is bad in law and they have quashed the summons. Therefore, the authority which the police or which gives the legal sanction is the registration of the FIR. It is a different matter for the police, even after the merely because the magistrate has made an endorsement, directed the police to register the FIR, does not necessarily make the police to file a positive report. Police, based on the investigations made, based on recording of statements, collection of material, either by way of documentary evidence or oral statements, or the seizure of material objects, what we call as MOs, then if it comes to the conclusion that there is no offense or cognizable case is made out, they can file a final report or a negative report to the magistrate. And again, the magistrate is empowered either to accept it, reject it, or direct the police to do a further investigation. Or suo motu can reopen and direct the police to further investigate the matter. This is how the criminal law is set in motion. Once this section 156(3) is set in motion, this deals with information to the police and the power to investigate. I have already brought out or referred to the various sections earlier, starting from complaint, investigation, and officer in charge of the police station. Now coming back to section 154, which is an information in cognizable cases, then what is the contents of those information is prescribed. The conditions, what are the conditions to record an FIR? It has also been categorized. The information given to the police officer must not be vague, but must be definite for the police to start the investigation or to take or initiate any action or to initiate or set the criminal law into motion. You may have come across cases whether a telephonic information can be recorded as an FIR. The answer is again twofold, yes and no. Why yes? Yes, for the reason, if it discloses or if it is definite, it is not vague, if it gives the particulars, then the police can take it as an FIR. Otherwise, if there is a phone call received by the officer in charge of the police station stating that there is a dead body laying here, so and so place, then the connection goes off. Then that is not definite information, because it could have been caused by an accident, it could have been murder, or it could have the person would have swooned and fallen off. Therefore, it is for the police officer to go to the place of occurrence and then decide. Then on the collection of evidence or recording of statements from the witnesses who are present in the nearby places, then he registers an FIR. Suppose if the information reveals that so and so, and if he sees some bodily injuries which could have been fatal, then he can register straight away as a case under 302. And it is also important to note, it is not always required for the police to know who committed the offense. Even for the magistrate, he only takes cognizance of the offense and not the offender. We have seen in so many FIRs, like so-and-so and various other persons, so-and-so and various other unknown persons, and so-and-so versus 50 unknown persons. All these are permitted because it is only an FIR. FIR is not an encyclopedia. All it has to record is only the gist, the definite information which the police officer receives, and once it discloses a cognizable offense, then he proceeds to investigate. Then if it is only an oral information, then what the police officer is required to do? He is required to register it. Register it by in the sense that he used to record it, he can himself record it, or he can ask the writer to record it and read it over to the complainant or the informant and asks him to verify. And after affixing his signature, then it must be entered in a book kept separately for that purpose. Each state government has prescribed the form in which the FIRs are now to be recorded. It contains all the particulars. As far as our state of Tamil Nadu is concerned, all these forms and these FIRs are now, you can give a complaint online to the Commissioner of Police and you get the acknowledgement almost in, depending on the nature of case, in 24 hours. Then you can access the FIR from the website of the Commissioner of Police. It's a Greater Chennai Corporation or Greater Chennai as far as Chennai is concerned. Similarly, it has been extended to the districts in Tamil Nadu also. The object is to set the criminal law in motion. These are all in respect of a cognizable case. If the offense is not a cognizable one, if it is only a non-cognizable one, then the police must keep their hands off. The police is required to approach the magistrate. The magistrate, on seeing the contents of the complaint, passes an order under clause 2 of section 155, based on which the investigation commences, because there is a bar in commencing the investigation if it is a non-cognizable case. Then what determines if the report is an FIR or not? As I had mentioned already, the information must be definite and not vague. And the information can be given by anyone. The information need not even name an offender or other witnesses. It is only an information to set the law in motion, based on which the police registers the case and starts the investigation. There are also occasions which you might have come across. There may be a complaint, there may be a counter complaint. These two are different aspects. If a complaint is registered initially, if another complaint is given, again, it should not be construed as a second FIR. Second FIR is back, is what the Supreme Court says from T.T. Antony's case, in that too in respect of the same offense. Suppose if the second FIR discloses any other offense in respect of any other person, in respect of any other occurrence, then it is permitted. If it is a case of case and counter, then the counter case given by that informant, if it also relates to an incident giving a rival version, though it will be styled as two FIRs, the police is still bound to register that FIR and can take up the investigation together. The general idea of section 156 is the police officer's power to investigate a cognizable case. As the section stipulates, the police officer's power to investigate a cognizable offense under subsection 3 of section 156, any magistrate who has jurisdiction under section 190 of the CRPC can take cognizance of the offences, which is captioned as cognizance of offences by magistrates, to order such an investigation as contemplated under section 156 clause 1. The magistrate, again, as I said, indicated earlier, has three options. A, accept the report as it is and take cognizance of the offence, in which case he proceeds in the case. Suppose on perusal of this complaint, of this petition, if he comes to the conclusion that there is no offence made out, he can disagree with the petition and close the case. There may also be some cases where there may be some gaps in the petition, or the magistrate may have some doubts in his mind. Then he can direct the police to further investigation and file the report under section 156 clause 3 of the CRPC. It is also important to note at this juncture that the accused has absolutely no right to intervene in these proceedings, to have his say. There are any number of judgments, the law is well settled as far as this aspect is concerned. However, if the case goes by way of a revision, assuming so, suppose if the magistrate refuses to take cognizance, magistrate disagrees with the report, and even after a further report is filed, the police magistrate says does not feel that it makes out a cognizable case, he closes the petition or dismisses the petition. Then that order becomes a judicial order, and the judicial order is subject matter of challenge by way of a revision to the jurisdictional superior court. When that happens, then the other party becomes an aggrieved party. Then he has a right to intervene and justify the order of the magistrate. It is only at the initial stage, at the original complaint stage, where a person appears before the magistrate and gives a complaint, and that the magistrate is in the process of examining the complaint, the person accused of that offence has no say in that matter, and he has no right to be heard. Once the magistrate, again, there are two things. The petition simply says, it is therefore most respectfully prayed that this honorable court may direct the police to investigate as per clause 3 of 156 of the CRPC and thus render justice. If that is the prayer in the petition, Supreme Court has held that if that is the case, you cannot take cognizance of the case. You have to necessarily direct the police to investigate. On the other hand, if it only says take the complaint on file and deal with the accused in accordance with law, then there the magistrate has an option. He can peruse the complaint. Since he is not called upon to enter into an investigation by himself, he can direct the police to investigate and file a report. On the other hand, on the face of it, if the petition makes out a case, then it becomes the complaint. And the magistrate, jurisdictional magistrate, invoking the powers and as contemplated under section 190 of the CRPC, takes cognizance of the case. If he takes cognizance of the case at this stage, it is provided under section 191 clause A. Suppose if it is through the police, it comes under section 190 clause 1 clause B, where the police, after investigation, files a report before the magistrate. He takes cognizance under 191B. Third case is 191C, are in two parts. One, after filing of the police report, the magistrate can direct the police that this is not sufficient. I would want you, or I direct you to make a further investigation and file a report. Then the second part deals with the suo motu powers of the magistrate. The magistrate suo motu can take cognizance. That is what is provided under section 190(1)(c). As I had in the preamble introductory, I have made clear that this, since section 156(3) is a judicial order, the magistrate is called upon to see for the limited purpose whether the petition or the complaint makes out an offense, and then makes an endorsement directing the police to file a report. Merely because there is a direction by the magistrate to investigate, the police, after investigation, comes to the conclusion that no offense is made out, they are fully empowered to file a negative report. Then again, the negative report can be accepted or need not be accepted by the magistrate. He can either take cognizance or he may direct the police to further investigate. And then even after further investigation, if the complaint is closed, then the magistrate is required, is mandated in law to give notice to the person who is the informant or the person aggrieved. Once that notice goes to the person, he is fully within his powers to file a petition, what we generally call a protest petition, before the magistrate. In the protest petition, it is dealt with as a petition like any other petition, where the de facto complainant or the informant or the complainant is heard, and he is well within his rights to justify that the complaint is made out. And notice is issued to the other person, the accused, to call upon him to answer the governments made in the protest petition. A detailed hearing is heard. Then the magistrate can either accept the protest petition, in which case he will issue summons to the accused and proceed with the criminal case, or he may dismiss the protest petition. If he dismisses the protest petition, the person, the de facto complainant or the informant, has a right to approach the superior court, maybe the district court or the high court, as the case may be. That depends on the order passed by the magistrate or the session judge or the special judge. Once the revision is filed, then as per the basic principles or requirements of a natural justice, notice if the revision is found to be prima facie found to be made out, then notice is issued to the person, to the other respondent. Then it is heard and the matter can be proceeded up to the Supreme Court. The third, after the third stage, or the other alternate open to the complainant, is to appear before the magistrate by way of a private complaint under section 200 Cr.P.C. And at the time he is given an option, either he must be heard, his statement is recorded, what we call as one statement by the magistrate. And if he has got any other witnesses to support his case, they can also appear on that appointed date, and the sworn statements are recorded by the magistrate. This exemption is given provided the complainant is a public servant. They are exempted, and the petition given by them is taken, the complaint given by them, based on the prima facie material disclosed in the complaint. Summons is issued and process is issued to the persons accused of the offense under section 204. These are cases where you might have come across on the economic offenses side, like a customs prosecution, income tax prosecution, or central excise prosecution. Those cases, you will find only that the person who is authorized to file the complaint by his superiors presents the complaint before the jurisdictional magistrate, and the jurisdictional magistrates, based on the averments, issues the process. In fact, in Chennai city, we have two courts, Economic Offences Court 1 and 2, where exclusively for these type of cases are being dealt with by them. If the magistrate proceeds to hear some more witnesses, he can direct the complainant to produce more witnesses to examine. This is what is inquired as per section 202 of the CRPC. As per 202 of the CRPC, after conducting an inquiry, if the magistrate comes to the conclusion that the offence is made out, then he issues notice. On the other hand, if he comes to the conclusion that no offence is made out, no criminal case is made out, therefore there is no worth proceeding this matter criminally. Sometimes it may it may appear to be a civil case, and you should not permit a civil case to be give a criminal color to the civil case and proceed in a criminal court. If he comes to that conclusion, he simply dismisses the complaint under section 203. Therefore, section 156 is always at the pre-cognizance stage, and 202 is a post-cognizance stage. There are a couple of judgments which I will refer to a little later in this. Now, dealing with this section 156.3 CRPC, there are judgments, various judgments. Few important judgments which were delivered by the Honorable Supreme Court of India recently is the one relating to Vinubai Haribai Malaviya versus State of Gujarat, which is reported in 2019, volume 17 SEC, page 1. This is by a larger bench of 3 judges, penned on by His Lordship Justice Rohinton Fali Nariman. The point which was involved in this case, whether after taking cognizance of the offence by the magistrate, whether he can order further investigation. Further investigation is permitted at any stage from the point of view of the investigating officer, even after filing a charge sheet under 173 clause 2, if some further material surfaces at a later point of time, notwithstanding the fact that a complaint was presented before the learned magistrate and cognizance has also been taken, whether the police or the magistrate can order further investigation, or the police can file a petition under 173 clause 8 for a further investigation. The Supreme Court said yes. There were some judgments earlier taking a different note to the effect that once the magistrate takes cognizance, then it was little doubtful whether he can take up or entertain an application. However, way back in 1977 in Ramlal Narang's case, the Supreme Court has settled this position, wherein that it is entirely in the realm of the investigation officer who is in charge of that case. If he comes to know of certain important fact which was not available with him at the time of filing the charge sheet, then he can make an application before the magistrate for further investigation. Though it is not mandatory, but however, to uphold the majesty of law, the investigating officer it was suggested to uphold the majesty to make an application, which is to inform the magistrate of the further material which emanated later, based on which the police wanted to proceed further. But at the same time, where a case which I am now doing, there has been an instance that the application filed for further investigation was dismissed by the magistrate for various reasons. That is also, once you file an application, notwithstanding the fact that it is only a formal application, the magistrate is fully within his powers to examine that 173(8) petition and sees it is not a tool to harass the person or to rope in some other person or to implicate some other person on a false charge. For that, he may have to examine the petition filed under 173 clause 8. On going through that, and he will have to necessarily see what are the documents, what are the statements which were originally accompanied the charge sheet under 173 clause 2. In another case, where it was verbatim the same, but except for the reason for some further material surfaced at a later point of time, there was nothing provided in the petition. The magistrate, on examining the averments made in the petition and the accompanying documents, came to the categorical conclusion, this is nothing but you are trying to reinvestigate the case. You are trying to implicate someone for your ulterior motive. Therefore, this I cannot permit. Therefore, the magistrate is also well within his rights to dismiss that 173(8) petition filed by the police. Therefore, it is not automatic. It is a different matter that any order passed by the magistrate or the special judge or the district judge is amenable to divisional jurisdiction to the High Court. That is a different aspect altogether. Now, in this Vinubai, coming back to this Vinubai's case, the Honorable Supreme Court said, the powers given to the magistrate under Section 156, Clause 3 is wide. It is not restricted. But there they had made a caveat, or there was a suggestion that this can happen only till the trial goes on. But it was also interpreted therein. Trial means till judgment is delivered. Therefore, at any point of time, it is well within the realm of the magistrate, invoking the powers under Section 156, Clause 3 of the Cr.P.C, to direct the police to further investigate into the matter. And therefore, merely because he has taken cognizance of the matter, does not restrict his powers to invoke Clause 3 of 156. In another case, which is a case of Madhubala versus Suresh Kumar and others, reported in 1997, Volume 8, SEC 476. Again, it categorically says police must register a cognizable case. And if it is not so, the magistrate can direct the police to register the case. And merely because, and in this case, the magistrate has also taken liberty based on the report. He has directed the officer in the rank of an assistant commissioner of police to investigate. That was challenged. The High Court accepted the contention that the magistrate is not empowered to change the investigating officer or direct somebody else to investigate the case. Supreme Court said no. On going through the materials available on record, on going through the initial investigation conducted by the investigation officer at the first instance, and the order passed by the magistrate, the circumstances taken by the magistrate, which prompted the learned magistrate to appoint an officer in the level of an assistant commissioner of police to investigate the matter, cannot be found fault with. Therefore, the magistrate order was upheld. But at the same time, there is a caveat to this. Suppose if it is a case of which is investigated by the local police or the CCB or a CCB, the magistrate cannot direct change of investigation. The change of investigation is always with the constitutional courts, namely the High Court and the Supreme Court. In one case where the magistrate said, I'm not very happy with the investigation conducted, therefore I will transfer the investigation to the CBI. Supreme Court said, no, you have no powers to change the investigation. If at all, if there is a person aggrieved, it is the person aggrieved who can approach the court for a change of investigation for various reasons, A, B, and C, that the officer is biased and is deliberately letting off the accused persons. He is only deliberately setting some innocent persons just to show some case or to fill up the statistics. In those cases, and those are all beyond the purview or the powers of the magistrate, it is only the High Court which has power either under Article 226 or under Section 482 of the Cr.P.C to deal with such cases. Therefore, change of investigation is out of the realm of the magistrate. Therefore, a magistrate invoking powers under Clause 3 of Section 156 does not have any power to change the investigation. Then, similarly was the case of B. Jayaraman versus Anandaraj and another, 2015, Volume 15, SEC 758. There, the Honorable Supreme Court quotes an earlier judgment of 3 judges bench in the case of Bhagwan Singh versus Commissioner of Police, reported in 1985, Volume 2, SEC 537, wherein it stipulates what are the conditions which the magistrate has to follow when a complaint is present, when a report is present before him. Accept the report and take cognizance, disagree with the report and drop the proceedings, direct further investigation under Section 156, Clause 3. The only requirement is while accepting a negative report from the investigation officer, magistrate cannot file it or return the complaint or assign it to the records. But as I mentioned earlier, notice will have to go to the de facto complainant or the person aggrieved or the informant. She has to be heard. Otherwise, the order can be successfully challenged before the High Court. And there are judgments which say that the magistrate's failure to issue notice to the de facto complainant is bad in law, and therefore he is directed to issue notice, take the protest petition on file, and dispose of the matter in accordance with law. What is the form in which the petition under 156(3) is required to be filed? Previously, all of us who are been practicing in the trial court before the magistrate's court, all we mention is petition under section 156(3) and drop it or present it before the magistrate. But in the case of Priyanka Srivatsava versus State of UP, which is reported in 2015 volume 6 SEC 287, when the case reached the Supreme Court was shocked to note that by merely making a petition under section 156 clause 3, they were able to have FIRs registered. That was a case where the bank officials initiated proceedings against the borrowers when they committed default. And they were also invoked the provisions of the SARFAESI and started attachment proceedings. Some of the accused persons thought of a novel idea. Then they gave police complaints to the jurisdictional police complaining against the officers, and also presented 156(3) petitions before the magistrate, in which the magistrate merely made an endorsement, register and investigate. That case went up to the Supreme Court. Supreme Court was shocked to note that merely because some action was taken by the bank officials against these persons, just as a counterblast, you cannot misuse the criminal law like this. It is a clear case of abuse of process of court, and there is nothing wrong the bank has done. Attachment of property will not amount to breach of trust, or calling upon you to make the payment will not amount to cheating or misappropriation or any such thing. Therefore, Supreme Court made a strong observation against these things and made it mandatory to file an affidavit by the person. Whoever makes an application under section 156(3) must be supported by an affidavit. If it is, that is just to make him accountable so that he can be prosecuted for filing a false affidavit. We have also come across cases where summons was issued even to the President of India. These are all the instances which made the Honorable Supreme Court to pass a direction that unless an affidavit is accompanied by the petition in support of this 156(3), you cannot take that application on file. Then in the case of Sakari Vasu versus State of UP, they laid down what are the stages in which can you directly approach the High Court under 482. Suppose if you give a police complaint and the police officer refuses to register the complaint, then can you directly challenge that as an order, come to the High Court directly by way of a direction petition under section 482. Recently, our division bench has also held, and also following the judgments passed by the Honorable Supreme Court of India, if a police officer refuses to register the FIR, then it is open to the person to approach the superintendent of police, then go to the magistrate. If all these three things fail, come to the High Court. Otherwise, you cannot straight away rush to the High Court by filing a petition under 482. Otherwise, there were tons of petitions filed before the High Court invoking the power under section 482. Because 482 cannot be entertained in view of the presence of an effective alternate remedy under 156 clause 3 or under clause 2, where he can approach the district superintendent of police. So this was laid down in Sakari Vasu's case. And therefore, it was categorically held either Article 226 or 482 is not the proper remedy to approach the High Court when a complaint is refused to be registered by the police officer in charge of the police station. Then we come to the taking of cognizance, which I have already discussed earlier, that the conditions requisite for initiation of proceedings is contemplated under section 190 of the CRPC, which deals with cognizance of offences by magistrate. I have already categorized the three 191A, 191B, and 191C, and the circumstances in which they are taken cognizance by the magistrate. There is one more aspect as far while dealing with 156 clause 3 would be whether the magistrate, here the magistrate, he can also take into account either the special judge or the district judge, because they are also now empowered under some special enactments like the PC Act to take cognizance. A person can appear before the special court and present a complaint. If such a complaint is presented before the magistrate, if it is under the PC Act, whether 156(3) can be invoked? The answer is twofold. First of all, PC Act cases are to be filed under section 3 of the 3 and 6 of the Act only before the special court. And it is presided over by a district judge or a designated judge. Therefore, magistrate cannot touch the PC Act cases. Now, coming back to the jurisdictional court, whether the person who is empowered to deal with these PC Act cases can straightaway, by invoking the powers of section 156 clause 3, direct the police to investigate a PC Act offence which requires a sanction. Sanction is again two sanctions, one as contemplated in 197 CRPC and section 19 of the PC Act. Both say no court shall take cognizance of an offence unless a sanction is obtained. Now, an interesting question arose before the courts, which landed up again in the Honorable Supreme Court of India, to say whether the magistrate exercising powers under section 156 clause 3, when it is said that he is not taken cognizance, can he take up or direct the police to investigate into an offence which requires a sanction at the time of filing the charge sheet? As these are the cases which will, in a case of L. Narayanaswamy versus State of Karnataka, reported in 2016, 9 SEC 598, this exactly came up for consideration. The Honorable Supreme Court, while discussing an earlier case of Anil Kumar versus M.K. Ayyappa, reported in 2013, 10 SEC 705, it was held an order directing an investigation under 156 clause 3 cannot be passed without obtaining a valid sanction. However, there were also judgments while dealing with section 197, wherein 156(3) was liberally used. In one case which landed up in the Supreme Court, in the case of Manju Surana versus Anil Arora, reported in 2018, volume 5 SEC 557, the Honorable Supreme Court, after taking note of these judgments and also the other judgments, says whether two parameters can be taken or stipulated when sanction is required to take cognizance under the PC Act, and without which even an investigation cannot commence. Whether the same sanction in respect of the same public servant under 197, can it be stated that it is not required? Therefore, in this Manju Surana, they have formulated these points and referred it to the larger bench. We have examined the position even with the Supreme Court website, and till now, at the time of this webinar, I don't think the Supreme Court has decided this issue. It is still pending with the Honorable Supreme Court. But in the meantime, one matter reached the Calcutta High Court. And by a recent judgment of the Calcutta High Court, which was rendered on 25th of January 2022, in the case of Dr. Nazrul Islam versus Basudev Banerjee, reported in 2022 SEC Online Calcutta 183, the Honorable High Court of Calcutta, after taking note of these two judgments are used, came to the conclusion, when this is the position, it has been the consistent stand of the courts to take the last reported judgment. Therefore, following the latest or the last judgment, held that sanction is required. Therefore, this is the position as far as requirement of a sanction while invoking the powers of the magistrate under section 156 clause 3. Therefore, this matter is not free from doubt. Till the Honorable Supreme Court decides this issue, we'll have to keep our fingers crossed. It depends on the jurisdictional high courts, either to follow the Calcutta High Court or any other high court. It can come to its own conclusion or defer the decision till the Honorable Supreme Court decides the matter. The comparison between 156 clause 3 and section 1202 is only this. As I had mentioned earlier, 156 clause 3 is in chapter 12, which deals with information to the police and their power to investigate. 202 is placed in chapter 15, where the complaints are made to the magistrate. Then, as per 156 clause 3, investigation is directed to be is directed by the magistrate under chapter 12, which is a cognizance stage, whereas the inquiry as ordered by the magistrate under 202 is the post-cognizance, because he examines the complainant by taking cognizance of the private complaint and examining the witnesses present, then proceeds under section 202 to inquire into the matter. Therefore, this is the difference between 156 clause 3 and section 202. This has been held so by the Honorable Supreme Court of India in the case of Ramesh Bhai Pandurao Hedu versus State of Gujarat, reported in 2010, volume 4, SCC, page 195. 185. Where they distinguish between 156 clause 3 and 202. And as I had already mentioned earlier, magistrate cannot direct the CBI to register an FIR and investigate. The judgment is Central Bureau of Investigation versus State of Rajasthan and another, reported in 2001, volume 3, SCC, page 333. Wherein they say that no such directions can be given by the magistrate. It is only left to the constitutional courts to decide these issues. With that, I think I have taken my allotted time. Mr. Vikas.
In fact, it was going so seamlessly, one never realized that how the time went. Yeah.
Thank you.
It's the other way around. This is by Amit
I've
Sharma.
asked my junior to share the PowerPoint presentation.
We have shared it. We have shared it on the WhatsApp groups, coupled with on this platform also.
Oh, all right.
Yeah.
Then great.
Yeah. I was saying that, and in fact, I had read it before the session was going to go live. I found that it has a bird eye view.
Yeah.
Bird's eye. YouTube, what we call in the YouTube to create the shots. So it's not a shot in the YouTube fashion, but at least it's in the PDF type where one can have the entire gist of that.
If you want yeah.
Pardon?
No, if you want it as a word also, I can ask them to send it to your email.
No, it's fine. It's fine.
Yeah.
Or I will ask your associate to do it. Amit Sharma says
she can do it. Vandana will do it.
Yeah, Vandana will do it.
Yeah.
Amit Sharma says, I have filed an application under section 156(3) of CRPC. It was dismissed by the CGM after 4 years. It was not even taken up as a complaint under section 200. What is the law regarding the same, and do I have a remedy?
Certainly you have a remedy. In fact, you need not have waited for 4 years. You could have made an application to the magistrate or straight away sought a direction under 482 from the High Court, because 482 is in 3 parts. To enforce the orders passed, give directions, then for securing the ends of justice to prevent abuse of process of court. Now here is a case, magistrate cannot, is not at all justified in keeping a petition for 4 years and then dismissing it. Then if he had not availed or approached the High Court earlier, that order can be challenged, as I said, even in this speech, that it is amenable to revisional jurisdiction. You can approach the High Court under 397 or 401 of the CRPC.
Yeah.
Order can be challenged.
But that time lag of 4 years is he has to justify.
Yeah, that because he can say only from the date of the order. He will not have, for the filing thing, it will be numbered.
Yeah.
Because you go only from the order 90 days.
Yeah.
It is, High Court will definitely ask him, what are you doing all these years? Whether anything survives the complaint at all after 4 years, that will depend on the nature of the offense.
Yeah.
Suppose if the offense itself is time bound, if it has to be filed within 3 years under 468 CRPC. So we have to also be vigilant. We can't be waiting for 4 years.
Vigilantabus, non-dormantivus.
Yes.
Complaint filed under section 156(3) was dismissed and proceeded under section 200 CRPC for pre-summoning evidence. Order was challenged before the sessions for revision under section 397, but order passed by the magistrate was withheld. Can both the orders be challenged before the High Court under section 482, or is it a bar under section 397?
No, there is only, what is the order passed? I didn't get you clear. See, one is a 156(3) petition. And it is stated as a 200 complaint. Yes. And then cognizance taken and summons issued.
Yeah.
That can be challenged. That is only one order. What is the other order?
Order was challenged before the session for revision under 397. But order passed by magistrate was withheld.
See, even the magistrate, see, that is why even in this thing I had indicated, if the petition says take cognizance or that deal with the accused in accordance with law, the magistrate is fully within his powers to treat it as a private complaint, issue summons. That is permissible. There is one judgment of the Supreme Court which says that if the prayer itself is only for 156(3) and if it requires some investigation to be done by the police, the magistrate is not empowered to investigate. Therefore, he cannot take cognizance and therefore he is necessarily bound to direct the police to investigate.
This is, will a writ petition under Article 226 be maintainable at a High Court as a remedy to complainant once 156(3) and complaint under section 200 has failed to get the FIR registered?
See, it depends on the High Court. Madras High Court does not entertain 226. It entertains 482. You can file a 482 petition seeking a direction, provided you had followed those 3 stages. Give a complaint to the police, sending it to the superintendent of police, then the third is 156(3). Once you fail in all these things, then only it can be entertained. Recently, Supreme Court, our Madras High Court, there is a division bench. After there was a difference of opinion between 2 learned single judges, they went into great detail about this. They now laid down that unless these 3 remedies contemplated are exhausted, you cannot directly approach the High Court under 482. Generally, Madras High Court does not entertain writ petitions in criminal matters unless only of late they have started entertaining, which is stated as a criminal 226, and it is posted before the 482 judge, not before the 226 judge, based on the prayer made in the petition. So you can approach the High Court only after exhausting the remedy, not directly, and not by way of a writ petition, only by under 482 as far as Madras High Court is concerned.
I think that Cr.P.C judgment would come into play.
Yes, yes.
And otherwise, we have done a session by Sandeep Chota, who was the state counsel in that Jayalalitha's case. He can watch that webinar on interplay between 482 and 226.
Yes, yes, it interplay only.
Yeah. Now we have a session by Sandeep Chota, who was a special prosecutor in that Jayalalitha's case in Karnataka.
I appeared for Shashikala in that case.
Okay. That's why your knowledge is quite, you can explain things threadbare. Once you go deeper into such sessions, as a practicing lawyer, then you can understand the nitty-gritties. This is by Parian. Magistrate ordered the police to conduct an inquiry and file a report by exercising the powers under section 156(3). Police conducted the inquiry and closed the complaint and produced negative report. As the complaint is false. Is the procedure correct?
This is by whom? I'm seeing on my screen.
GKP, he's a lawyer from your place.
Yeah, 1 second.
That is at 6:45.
Yeah, 646. Yes. Magistrate ordered the police to conduct inquiry and file a report. By exercising section 156(3), police conducted inquiry and closed the complaint and produced negative report as if complaint is false. See, this is the case where when a negative report is filed, the magistrate, on accepting that report, is bound to issue notice to the de facto complainant. The de facto complainant, if the de facto complainant on his own comes to know that the police has filed a negative report, he can approach the magistrate and file a protest petition. If a protest petition is filed, that has to be treated as a complaint, then it has to be adjudicated by the magistrate and pass an order. He cannot simply take the negative report and direct the complaint, and the complainant is not remediless. He has to hear the complainant.
This is by Paul. The inaction of the forest officials resulted in the death by the wild animals and medical injury. A complaint was filed against the forest officer at the local police station. However, no action was taken by the complaint or on the complaint. Could the complaint be filed under section 156(3)?
See, there if it is a forest officer, then the question of sanction will come under 197. Sanction must be obtained. So magistrate is not empowered to take cognizance.
You can watch one of the webinars on sanction by Mr. P.S. Rajagopal, a senior advocate on a YouTube channel.
Yeah, okay.
Yeah. Advocate Suman, I have given a written complaint to the police. However, they transferred on the wrong reasons of jurisdiction. Again, where they have transferred, the police again takes a written statement and just registers only. What is the remedy?
See, Supreme Court in when a case decided, I think way back in 2008, police cannot refuse to register a complaint. They have to register a complaint. If it comes to their knowledge that they don't have jurisdiction, then they will have to send that complaint lock, stock and barrel to the jurisdictional police station. Then it is for the jurisdictional police station to conduct the investigation, because of various aspects, including territorial jurisdiction. But if it is going backwards and forwards like this, he can approach the High Court.
This is 156(3) petition ordered on receipt of specific directions from the jurisdictional magistrate. The magistrate, without registration of the FIR, inquiry was conducted and closed. Is that the right procedure?
See, again, it is based on the facts. We do not know what the complaint disclosed. Magistrate is well within his right, even before ordering exercising his power under 156 clause 3, directing the police to register the case, he must be satisfied that it makes out a cognizable offense. What if the magistrate comes to the conclusion that no cognizable offense is made out? Then he has to only close it. If he closes it, he is not remediless. He can challenge it before the High Court or the District Court under 397 Cr.P.C.
This is by Priya Reddy. How long one has to wait for the magistrate to come back with either of the decision accepting or rejecting under section 156(3)?
See, it says only reasonable time. Reasonable time, as far as the magistrate is concerned, in respect of these matters, cannot go beyond 1 week unless he has to record reasons. Otherwise, he can approach the High Court under 482, giving a direction to the magistrate to dispose of your application.
Yeah, I will just check it on the YouTube. The amount of questions are pouring up. It shows that the people are watching it very in a lively manner to understand things. This is by Kunal Agarwal. Can magistrate direct the police to investigate the matter and also order for the incriminating evidence?
And also
order for the incriminating evidence.
No. See, once the direction is given to the investigating officer, then it passes the realm from the magistrate to the investigating officer. It is for the investigating officer to investigate the case in accordance with law. There is no question of giving any direction to get incriminating evidence. If such an order is passed, then the magistrate is preconceived that will be struck down. Magistrate can only direct the police to investigate and file a report.
This is Akshay Kumar. Is the order of police custody an interlocutory order? Doesn't, no, this is not with the session, so we will not take it. Is it necessary to join the accused as a party in an application under section 153? This is by Aniket Satpute.
See, 156(3) petition, if it is presented before court, as practicing lawyers would know, you will give the name of the accused also. Otherwise, if it is even in the complaint, unless it is not known the person who has committed the offense, then you say this is only an offense which has been committed, then the magistrate take cognizance of the offense under 190, or if the complaint makes out a cognizable offense, he endorses it to the police. Police will register this as an FIR, making note of the name of the complainant and some unknown persons. Then he proceeds to the spot to investigate. Then he includes the accused at the time of filing the final report.
Yeah, this is by Ravi. Is power of the magistrate to ask questions for status report of investigation come under section 156(3), and can status report be demanded from police only on the basis of complaint given to the police of information of a non-cognizable offense to police when FIR is not being registered?
See, there are two things which is clubbed into one. See, non-cognizable cases stand on a completely different footing. That has to be dealt with under 155 clause 2. If it is a cognizable offense, the magistrate, after making an endorsement to the police, he is well within his powers to seek for a status report.
Yeah. The questions are there. I'm just wrapping it off with the tomorrow's session. So it is in fact in tandem with today's. Tomorrow we will be having a session on trial by magistrate, pre-cognizance, cognizance and inquiry. So that is by Murthy Nayak, a senior advocate from Karnataka Bar Association. So do stay connected with us tomorrow at 6 p.m. And thank you, Mr. Manishankar.
Thank you.
It was a pleasure connecting with you. The way and the ease with which you have explained things, it's fantastic. And the way it has been latched up on the YouTube, it shows that people have actually loved it. Thank you, everyone. Stay safe.
Thank you.
Stay
My
blessed.
pleasure. Thank you.
Thank you.